Thank you, John. Thank you all. Good morning. Now, I'm hoping that most, if not all of you, can you hear me all right? I'm hoping most, if not all of you, will have a copy of Section 84 of the Property Law Act. It was available outside. I'll just begin briefly by speaking to that section, because it's useful to just lay out the legislative framework. Now, Section 84 of the Property Law Act is the section that permits the Supreme Court to modify or extinguish a restrictive covenant. And the first point to note is that it only applies to restrictive covenants. If what we're trying to modify or extinguish is an easement, you cannot go under Section 84. Now, Section 84 then provides 4 bases, somewhat confusingly set out in 3 subsections, for the extinguishment of a restrictive covenant. And those bases are the obsolescence of the covenants, that the covenant impedes reasonable user without providing any practical benefits to the beneficiaries, that there is the consent of the beneficiaries to the removal of the easement, and finally, that the proposed discharge or modification will not substantially injure the persons entitled to the benefit of the restriction. Now, I don't propose to talk in any detail about Section 84(1)(b) being the consent provisions, because basically, if you can obtain the consent of the beneficiaries, your application will probably be successful. However, I would note that the power under Section 84 remains ultimately discretionary, and the court may choose not to modify or extinguish a restrictive covenant, even where the power to do so is engaged. That is, even if you do have consent, the court may actually just say, well, I'm not satisfied that I should make the changes even though they've been consented to. Now, that's rare, but it can happen. So that's just something to bear in mind. So I've already made 2 of the 3 general observations I make in my paper about Section 84. First, it doesn't apply to easements, or is generally understood as not applying to easements. And secondly, that the power is discretionary and there is a power to refuse to make a modification even where the power is enlivened. The final general observation I would like to make about Section 84 is that the onus is obviously on the applicant for discharge to show that it should be discharged. It's not a matter of saying, well, we've discharged our burden, therefore the other side has to show that the thing should be retained. The onus is simply on you to show that it should be removed or modified in the way you are proposing. Now, generally speaking, the Supreme Court has taken what can fairly be described as a conservative approach to the exercise of its powers under Section 84. It recognizes that what you're doing is removing or destroying a property right, and it is very reluctant to do that. So, for example, in relation to the second limb of the test under Section 84(1)(a), that is the question of whether an easement or a restrictive covenant, restricts reasonable user, you, the applicant, on the conservative approach, must show that it impedes every reasonable use that can be made of the land. Not just the use you're proposing, not just the use that is currently being made, but every reasonable use. And obviously, that is intensely problematic. Secondly, the conservative approach treats town planning principles as irrelevant. So, for example, town planning these days tends to favor higher density development, but that is irrelevant when you are, for example, seeking the removal of a single dwelling covenant that would facilitate higher density living. Now, there is an alternative approach. It has only been followed in one case, and that is the decision of Stanhill Proprietary Limited in Jackson, a decision of His Honour Justice Morris, as he then was. In that case, His Honour called for a more robust approach to the power under Section 84, basically arguing that town planning considerations should be considered relevant and that the section should really be read in a more naturalistic way. And an example of how this would apply is His Honour said that on this basis, a covenant would impede reasonable use if it impeded a reasonable use. So, for example, in that case, it was a single dwelling covenant. The people wanted to use what was quite a large block of land to develop more than one dwelling. His Honour said, well, that's a reasonable use of the land. It is impeded, therefore, under Section 84(1), the second limb of Section 84(1)(a), I would say the power is enlivened. So obviously, that's a favourable approach if you're acting for a person who is seeking to have a covenant removed. Now, the difficulty, of course, is that this approach has not been expressly followed by any other court. Some courts do appear to have applied it sub silentio, as it were. They certainly in, I think, Fraser and De Pauli, Justice Coghlan appeared to apply it. But no one has ever expressly adopted it. Certainly the Court of Appeal has never expressly adopted it, even though Justice Cairo says it has much to recommend it. In fact, more recently, we've seen two judgments that suggest that Stanhill should not be followed. Those are the decision of Justice Kavanaugh in Prowse and Johnstone, and there are references to this, and also the decision of Associate Justice Daly in Grant v. Preece. So you will have an uphill battle trying to argue that Stanhill should continue to be applied, but it is open to you to make that argument. And it may be favorable, well, it generally will be favorable to do so. I'd like to turn now to the actual tests under Section 84. Now, as I've gone through, there are 4 limbs. The first one is obsolescence, so I'll deal with that. Now, some of what Tom has already said is relevant here. What you're really looking at is obsolescence, is changes in the nature of the neighborhood that mean that the covenant is no longer relevant. So, for example, again, if you're looking at a 3-townhouse development with a single dwelling covenant restricting that, and you've got 3 townhouses on either side on blocks that were formerly burdened by a similar covenant, it would be open to you to argue, well, this covenant is no longer effective. The neighborhood character, which was intended to be preserved by this covenant, has simply gone. It's well recognized, really, that single dwelling covenants aim to preserve a particular neighborhood character, and many of the extant forms of restrictive covenants as a whole, height restrictions, building material restrictions, are really aimed at preserving a particular neighborhood character. And if you can show that neighborhood character has either ceased to exist or has been significantly eroded in some way, then your chances of succeeding under Section 84(1)A, the first limb of Section 84(1)A, will be better. That said, the test for obsolescence is very high. In fact, all the tests I'm going to discuss are difficult to succeed against. Certainly single dwelling covenants, provided the area is still broadly characterized by single dwellings with large green areas, will be very difficult to succeed against. So on paragraphs 13 and following of my paper, I just set out a number of questions that you would want to consider in making an application under the first limb of Section 84(1)A. What is the purpose of the covenant? What is the relevant neighborhood? And can the covenant still fulfill its purpose? Now, I briefly discussed purpose. That's a matter of interpretation of the particular covenant. It's actually quite hard to speak in the abstract about a restrictive covenant application because so much depends on the particular terms used. So is it a prohibition on constructing more than one dwelling house? Is it a prohibition on constructing a dwelling house? In Tonks and Tonks, a dwelling house was held to encompass multiple dwelling houses. It would have been different if the word a was replaced with the word one, for example. So really small differences. And again, this is a point Tom made in respect of the planning applications. But you do need to be looking at the text of the covenant to see what the purpose really is. The neighborhood, turning to the question of what is the neighborhood, that is a question of fact to be decided at the time of the relevant application. Now, there are 2 relevant issues here. First, if the covenant arises as a part of a building scheme, and I explained briefly what that is in paragraph 17, then it is likely the neighborhood will be the area affected by the building scheme. But as Tom says, it's often necessary to look at the title documents and perhaps go back to parent and grandparent titles to see where that building scheme itself comes from. If you don't have a building scheme, then the best way to deal with determination of the neighborhood is often to seek expert planning advice. Planners will be able to explain from a number of factors why a particular neighborhood should be construed as a neighborhood, and that'll be more persuasive, generally speaking, coming from an independent expert than it will coming from submissions from the bar table. And then I go on to talk about the continuing fulfillment of purpose. I don't really intend to say anything about that now because it is such a fact-based inquiry. The real question will be simply, well, this is what it's intended to do, this is what the neighborhood is, putting those two together, what do we have? So turning then to the second limb of section 84(1)(a), which is this impediment to reasonable user issue commencing in paragraph 21, there are two questions. Does the covenant impede reasonable user? And further, in doing so, does the covenant fail to secure any practical benefits? Now, I've already briefly discussed reasonable user and the very hard test that the court has imposed in respect of that. Generally speaking, for example, if you have a single dwelling covenant or a height restriction covenant, and people are already using that land for residence, that in and of itself is evidence that on the traditional approach, the reasonable use of the land is not impeded because it is already being used. So it's on the traditional approach, it will be very hard to succeed under that. If you can persuade a court to adopt the Stanhill approach, then your chances are better because presumably you wouldn't be applying unless the use you intended to do was impeded by the covenant. But you would still need to show that your proposed use was reasonable. It's very hard to say, again, in the abstract, what uses are going to be reasonable, but there's a couple of decided cases, at least in respect of single dwelling covenants, Stanhill and Fraser and DiPaolo, that show what kinds of intensity of development may be appropriate. So in Stanhill, this is paragraph 22d1, Roman numeral R1, Arabic numeral 1, Stanhill accepted that the development of 2 or 3 dwellings on land with an area of 1,133 square meters would be reasonable, but more than that would be debatable. By contrast, to some extent, in Fraser and DiPaolo, Coghlan found that development of 5 dwellings on a block of land with an area in excess of 1,400 square meters would not be a reasonable use. So, it will depend ultimately on the nature of the proposal. Perhaps more problematically, though, even on the Stanhill approach, you need to show that no practical benefits are secured in order to succeed on the second limb of 84(1)(a). And the courts have taken a fairly expansive approach to what is a practical benefit. If we look at 23b, you'll see a short list there, which includes sunlight, natural light, pleasant views, peace and quiet, open space, gardens, freedom from being overlooked, and the preservation of natural beauty. Now, in many cases, these kinds of practical benefits will not be the kind of thing that is actually expressly protected by the covenant. For example, a single dwelling covenant will not presumably say anything about the preservation of natural beauty, but it may be understood that one of the benefits that it actually does secure by reducing the intensity of development is that kind of benefit. So again, the test is a stringent one. If the covenant provides any practical benefit to the beneficiaries, then the test under the limb of section 84(1)(a) will not be made out. As I said, I don't intend to deal with section 84(1)(b), the consent provision, so I'll move straight on to section 84(1)(c). This is probably your best chance as an applicant because it's not a categorical test. The test is one of substantial injury. It doesn't require that there be no injury. Now, what is an injury? Well, the courts have said, the full court of the Victorian Supreme Court has said that there's a lot of overlap between section 84(1)(c) and the second limb of section 84(1)(a). That is, basically, if it's a practical benefit under the second limb of section 84(1)(a), the loss of that will often be an injury under section 84(1)(c). So it is quite expansive, and I think it's useful to just comment on 2 particular forms of injury. First, there's the injury in the form of the precedent effect. If the amendment to a restrictive covenant is authorized, then it will often be the case that that will change the character of the neighborhood, which in itself will facilitate further applications because you're already changing the character of the neighborhood. So the courts have recognized that by granting the application, that may in itself cause a form of injury. That said, the fact that there is a precedent in there is not necessarily determinative, and that's recently been reaffirmed by Justice Dixon in the case of Kohler and Rice. Even more recently, though, in Prowse and Johnstone, Kavanaugh has said that the concept of injury extends to intangibles. So aesthetic effects and so on. Now, again, that's quite consistent with what Tom was saying in relation to the VCAT applications. Now, how you apply that in practice can be quite difficult. I mean, if you've got a restrictive covenant that prevents, again, is a single dwelling covenant saying must be built of certain materials, and someone objects on aesthetic grounds based on, say, architectural style, it's hard to see how that benefit is really related, but I'm sure the courts will work that out. The second test is the injury must be substantial. So how do we assess the injury? And the answer is we compare what would be authorized under what was the original intended benefit of the unmodified covenant with what the benefit of the modified or extinguished covenant will be. Now, this points up a point that, again, Tom made, which is that removing a covenant is often a lot harder than modifying a covenant, because really you're looking at total loss of benefit there. And what the courts have said, and this was again the recent decision of Justice Kavanaugh in Prowse and Johnstone, is that the comparison requires a consideration of the worst that can be done under the original covenant with the worst that can be done under the modified covenant. Now, town planning considerations are relevant in this context. Justice Kavanaugh said it really needs to be a realistic assessment of what could actually be done on the land. So, you know, if the land is not going to have 5 townhouses built on it, that horrible can't be held up by objectors. But that ultimately the process we're looking at is one of simply comparing what you could do under the first covenant and what you can do afterwards, and saying, well, how big a difference is it really? Is it a substantial injury to the particular interests? So those are really the tests, and again, they are quite hard to discuss in the abstract. So I'm just going to move on in the final part of my talk to discuss some practical aspects of making an application, a number of which have already been touched on by Tom, as I've sort of flagged. So as a first step, it is always important to consider whether the covenant in question actually prohibits the use and development. And there are some interesting examples of situations in which one might expect the use and development to have been prohibited, but it wasn't. In particular, there's a decision of His Honour Justice Osborne in Re Longo, where it was held that an aged care facility was a dwelling house within the meaning of a covenant prohibiting the development of more than one dwelling house. And that's because ultimately His Honour said, well, it operates as one household. There are shared cooking facilities. There's actually a line of cases about whether or not flats which have the physical form of one dwelling can be considered to be a single dwelling. And ultimately, it really seems to turn on whether you have common spaces, whether you have common cooking facilities, and so on. So, for example, a hostel might be a dwelling house, but your actual block of flats with individual cooking areas would not be. But again, this just illustrates the importance of trying to figure out what the covenant actually prohibits. And again, small differences in language can be significant. I've already referred to tonks and tonks. The second matter you have to consider in looking at an application under Section 84, in my view, is the validity of the covenant in question. On one level, if the covenant's not valid, that will often be the end of it. If it can't be enforced, you needn't worry about it. It gets a little more complicated, though, because VCAT cannot issue a planning permit in breach of a restrictive covenant, registered restrictive covenant. And VCAT has recently said that if a covenant is registered, it's not for VCAT to consider the validity of that covenant. In those circumstances, if you need a planning permit, it may be necessary to have the covenant modified or extinguished, notwithstanding that it is actually formally invalid. So again, it's important to look at the issue of validity, but it doesn't mean that you won't need to make an application under Section 84. And what may be useful is there is a specific power under Section 84, subsection 2, to seek declarations from the Supreme Court in respect of restrictive covenants, in particular whether they apply, and if so, how. So you may just want to, if there is an issue as validity, you may want as a security to seek a declaration saying, actually, no, this is an invalid restrictive covenant and you're not affected by it. Another important issue in Section 84 applications is the issue of costs. Now, costs do not follow the event in Section 84 applications, which is potentially very significant if you are the applicant. Generally speaking, unsuccessful objectors will not be expected to bear their own costs. The best you will be looking at will probably be a no-costs order. So obviously that increases the cost to applicants of making applicants to the Supreme Court. And this was discussed in the judgment of Justice Morris in the cost judgment of Stanhill. In that case, he did say that if the applicant had been entirely successful in obtaining the modification sought, he would have made a no-costs order. But he did, in fact, did make an order requiring them to pay some percentage of the unsuccessful objector's costs. And there are cases before this making the same point. So realistically, a Section 84 application is not going to be a cheap endeavor, even if you succeed. And another issue in terms of this, of Section 84 applications, and this is one that Tom has touched on, is variation versus extinguishment. As Tom has already said, it's generally much easier to get a variation than it is to get an extinguishment. So if you can, it will often be tactically more favorable to just go for that. If you only need 2 townhouses on a lot, don't seek to have the single dwelling covenant extinguished, seek to have it modified to permit 2 townhouses. That way, the court will be able to say, well, there's still some restrictions on the development, and that worst case scenario comparison that we've discussed will be more favorable. Planning evidence I've already touched on, and again, this goes back to what Tom was saying, but it is very useful to have plans of what you propose to do with the site. In both Stanhill and Vracas, the court has commented adversely on the absence of planned evidence about what will be done with the site. And again, this goes back to the worst case comparison. If you can say, well, this is what we're going to do, this is how it'll be restricted by the new modified covenant, and the court can take some comfort from that. Whereas if you just turn up and say, we want to extinguish this single dwelling covenant, then the worst case scenario could be very bad indeed. So it will be useful to have plans, and again, I've already mentioned planning evidence in respect of defining the neighborhood. The final issue I'm going to talk to, and this sort of goes against some of what I've said, is that there may be some value in running an application under Section 84 sort of up the flagpole and seeing who salutes. What I mean by that is that there's a 2-stage process really with Section 84 applications where you make what is essentially an ex parte application to the court, and they will then order an amount of advertising. And then people who get the advert and think they wish to object can then make application to the court. If no one objects, then the court is likely to grant your application anyway, notwithstanding the existence of the discretion to which I've already referred. So sometimes there is some value in just making an application to the court and seeing whether anyone actually does object. That does involve incurring costs, and of course it may be that a large number of objectors come out and say, no, we're absolutely opposed to this, and realistically you've got no prospects of success. But if your client is dead set on seeking an amendment, then this may be a good way to at least test the waters before fully committing to the application. As I say, the downside is that it involves some cost. So that really concludes my paper.